Now, the Supreme Court has dismissed a petition filed by telecom companies to refigure adjusted gross revenues amid a long-standing dispute over payment of dues to the government. On October 9, remember viewers, last year, the top court had taken note of submissions of some telecommunication companies seeking listing of their pleas on adjusted gross revenue due issues. Vodafone India, Bharti Airtel and other companies had filed a curative petition against the court's October 2019 verdict in which they were directed to pay the government 92,000 crores within 3 months. In their petition, the telecom firms claimed a grave error by the Department of Telecommunication in calculating those dues, license fees and spectrum charges. I'm also being joined by a telecom expert, Anil Kumar, on the show to take us through what this verdict exactly means. Anil Kumar, thank you so much for speaking to NDTV firstly. And if you can explain the court's verdict to our viewers in simpler terms, what does this mean for telecom firms like Bharti Airtel and Vodafone India?
For the last 13 years, the Department of Telecommunication and telecom operators, they were fighting in various forums. And over a period of time that this license fees calculation method adopted by DOT is not correct. And DOT was taking a stand that their method is correct. The operators, they were calculating it in a different way. And the difference was to the tune of about 1 lakh crore rupees at that time. So over a period of time, this was pending with the tribunal, then Supreme Court. Then over this period, there was a lot of fight going on with the telecom operators. Finally, in 2019, October, there was a decision judgment by the Supreme Court that operator's stand is not correct. Department of Telecommunication stand is correct, and they gave verdict. As a result of that, about 2 lakh crore rupees AGR was due from various operators to the Department of Telecommunication. This included interest and on interest and penalty. So about 2 lakh crore rupees was coming out. Then telecom operators filed review petitions. That too also was rejected within 3 months of that verdict. Then after few judges retired who gave that verdict, in 2020, to 22, curative petition was filed about 2 years back by two operators initially, then later I think Tata also joined. They've challenged that method that there was a double calculation demand from the Department of Telecommunication, which should be relooked at by Supreme Court. Now today's judgment has come that they have dismissed all this. What is the impact of this judgment on operators? Vodafone Idea, so as per their revised calculation, so they stand to lose 37,000 crore rupees. Vodafone Idea's DOT calculation in case of Vodafone Idea is around 58,000 crore rupees. And the self-assessment made by Vodafone Idea is 21,000 crore rupees. So difference is 37,000 crore rupees. Similarly, Bharti Airtel Limited also will lose around 31,000 crore rupees in this verdict. Tata also stand to lose around 15,000 crore rupees. So these three operators together, 82,000 crore rupees, they stand to lose. So it's a verdict by Supreme Court. There is no further challenge. There can be curative petition is the final resource which an operator or a loser can take to the for the remedy. So this is a final verdict. And what is the impact on the consumer? Vodafone Idea is on a very weak footing. So they may have difficulty in their sustainability of their operation. Bharti Airtel Limited, they also have some difficulty, but they can overcome because their subscriber base and revenue is okay, acceptable. There is no impact on Geo or BSNL is government supported, so it will not have any much of impact. So main
Right.
impact is going to be Vodafone Idea and so some impact on Bharti Airtel.
Mr.
Though
Anil, the companies in their claim today, in the plea, they said that the center made calculation errors and imposed arbitrary penalties. How can this be possible if, you can tell our viewers in very simpler terms, how is this calculated? First of all, the spectrum fees and everything. And how can the companies claim that the center has made errors? Isn't there any rate that is fixed between the telecom firms and the center?
Yeah, so in the curity petition, they pointed out that there is a demand from some circle and which has been doubly calculated. No? Once it has been calculated in some other way by DOT, and another demand has come from circle that also has been added twice. So they wanted to that this addition by this method, no, by DOT should be removed, and then only the payment should be made. Means calculation should be made by DOT. This is a curative petition, which Supreme Court said that no way. It's already petition has been decided by Supreme Court, and then review petition also has been rejected by the same court. Now curative petition also has been decided. So I think there is some injustice to some operators in this judgment also, because if 2 plus 2 is not 4, then if somebody says it is 5, then it should be corrected. So that correction has not been done by DOT. They should do it by themselves, but they are not doing. They have been prohibited by Supreme Court judgment. Review petition in the review petition also, in the main petition also.
Right.
So that stand has been now upheld by in the curative petition.
Right. Mr. Anil, just stay with me. My reporter and my colleague Varun Ghakar is also joining me for more details. Varun, take our viewers through this verdict that has come out. The curative petition of the telecom companies have now been rejected on adjusted gross revenues, and here we are not talking about lakhs or some small amount, but crores of revenue. ADR has been pending, and still no clarity is coming out from the companies. They are saying the center is manipulating. The center says there is no wrongly calculated move that has been said to the companies. What does this mean exactly?
Yeah, so that's right. So Supreme Court has rejected the pleas that were filed by Vodafone Idea, Bharti Airtel and various other telcos seeking a limited reconsideration of a top court 2019 which held that these telecom companies have to include their non-core revenues while calculating their adjusted gross revenues. Now, what is adjusted gross revenue, or AGR as we refer to it in common parlance? AGR is the basis of a revenue sharing mechanism between the government and the telecom operators. Now, under this mechanism, the operators have to pay a certain licensing fee and a spectrum usage fee to the Department of Telecommunications. Now, the DOT calculates this fee as a percentage of the AGR. However, the definition of what constituted AGR has been in dispute since 2005. Now, in October 2019, the Supreme Court ruled that non-core revenues must be included while calculating the AGR, which ended a 14-year-long battle between the telecom operators and the government on the definition of AGR. Now, the 2019 judgment dealt a crippling blow to the bruised industry that stared at dues, especially Vodafone Idea and Bharti Airtel. They were staring at dues over and above 1 lakh crore rupees.
Varun, stay with me. Mr. Anil, as we were talking about, that the curative petition is the last attempt that the telecom companies can make. Now that it has been rejected, what's the next move for telecom companies? Are they ready to pay to the center or not?
No, they'll have to pay. There is no option before them. So otherwise, they have to wind up their operations. If, for example, Vodafone Idea says they cannot pay, then the process is NCLT. So they'll have to wind up, because the commitment they made to to the government as per their license condition, they have to pay the AGR. AGR has now been finally calculated by the Supreme Court. And then that is a final verdict. They have to pay. If they don't abide by that, then there is a contempt, and also there is NCLT process before DOT can take them to the NCLT for recovery of their dues.
Right. Mr. Anil, stay with me. Varun, if I can come back to you, what other actions are there, or the courses that are there with the Department of Telecommunication against these telecom companies, which if they now refuse to pay that ADR dues?
Yeah, so as Sir said, this is the final nail in the coffin for these telecom companies. As in, a curative petition is mostly the last resort for going over a judgment that you feel that is incorrect or has a manifest error in it. And the curative petition, since it has been now rejected, if the companies fail to pay or if they cannot pay,
right,
the companies will have to go through the NCLT route and the IBC will have to kick in.
So there will be some action that can be followed by the Department of Telecommunication. Can you list down the measures? What actions can Vodafone Idea, Bharti Airtel, these are big companies, what actions can they face if they fail to pay these dues? Mr. Anil, you can also take this question.
They will be held under contempt of court by the court, since this is a Supreme Court order.
Okay, as per the order, they'll have to abide by that. There is no other option. So DOT has to implement court's order. So
no, I'm asking if they do not still hold some objection to the way they have been imposed, they have been asked to pay, but what other actions can the government take to impose that they need to pay in a timely manner? They were asked to pay in 2019, they didn't. Now the curative petition, the last remedy, has been taken away from them. If there can be a timeline that can be set by the centre that in this much time they have to pay it.
That is already settled. So 10 years have been already given to them by the previous bench. So 10 years period, during the 10 years period, they can pay their dues with interest. So it's choice is before them if they want to pay right now everything or have that option of 10 years with interest. So there is no other payment or other way to get out of this judgment. They'll have to pay. So timeline has already been fixed by DOT and agreed by Supreme Court in 2019-20 itself that 10 years period is acceptable. So with interest, they'll have to pay the interest.
Right. So by 2030 is what you're saying is the timeline that has been already been set by the top court in 2019 when they said that the dues have to be paid by Vodafone and Bharti Airtel. And now that the last remedy has been rejected by the court, saying the curative petition has been rejected, the telecom companies are left with no choice but to pay the amount that has been given by the Department of Telecommunication. Well, with that, thank you so much, Mr. Anil Kumar, for joining us and explaining in such simpler terms what this verdict means. I also thank my colleague Varun for joining us and sharing those updates.